Okay, good afternoon, everyone. It is my honor as a ThyCa volunteer to welcome you to session 165, Protecting Yourself and Your Family by Planning Ahead by Monica Bryant. I'm going to give her the title Esquire, even though she told me it's not supposed to be said. She is a cancer rights attorney and chief operating officer of Triage Cancer, a nonprofit out of Chicago, Illinois. It is my distinct pleasure to not only sit in on this conference as well as attend the session, but to introduce Monica Bryant. Thank you, Monica. It is all yours.
Thank you so much, Timothy, and thank you all for being here to talk a little bit about planning ahead. We are going to take questions in the Q&A. So if you have questions as I'm talking, feel free to go ahead and type those in, and then we will get to them at the end of the session. So as Timothy mentioned, I am Chief Operating Officer for a nonprofit called Triage Cancer. And our mission is to provide education on all of the practical and legal issues that come up after a cancer diagnosis. So that really runs the gamut from things like health insurance to employment to, of course, what we're here to talk about today, estate planning. When we talk about estate planning, it can actually mean different things to different people. I like this definition because I think it really is sort of the most encompassing, but we're really talking about creating a plan to make sure that what you want to have happen happens around what happens to your property and your healthcare. And if you're in a situation where you're unable to express those wishes, who's going to make those decisions on your behalf? So estate planning is a challenging thing to talk about because we are ultimately talking about our own mortality, and death can be very sad and hard. But here's the thing. At some point, it is true for every single one of us, we're going to die. Now, certainly we hope it's not for many, 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 many years down the road, but it is an inevitable conclusion for each and every one of us. So I try my best to take some of the emotion out of estate planning and really just thinking about it as a to-do list or a plan, and being a little bit more cut and dry about it can sometimes make what's a hard emotional process a little bit easier. Now, when we think about who needs an estate plan, we certainly think, this lovely lady in the corner who is the oldest living person in the United States absolutely needs an estate plan. She is probably closer to her end than some others by virtue of her age. Certainly Beyonce and Jay-Z, who likely have more money than God at the moment, need an estate plan to figure out what's going to go on with their possessions and their money. These young professionals who may not have a ton that they own still need to think about some pieces of the estate plan. And then absolutely this family with younger children absolutely need to be considering an estate plan, if nothing else than to protect their minor children. But if you haven't planned, or you feel like, maybe I really need to revisit this, but I don't wanna, you are not alone. There are so many incredibly famous, incredibly wealthy people who have passed away without a will, including Sonny Bono of Sonny and Cher, Aretha Franklin, the queen of soul, most recently Chadwick Boseman, who's perhaps better known, also known as Black Panther, all passed away without a will. And studies have shown that somewhere around 68% of all Americans don't have a will, which is the most basic estate planning document. So if this is your first foray into thinking about estate planning, you're definitely not alone. And I'm delighted that you are here, and hopefully you'll have some really good takeaways after today to be able to move forward with your estate plan. Why do I think it's so important for everyone to plan their estate? There's lots of reasons, and all of these reasons may resonate with you, or you may just find one or two resonate with you. So first and foremost, you're documenting your wishes. There are some real financial ramifications around not planning your estate, which we'll talk about in a little bit. I think there's some peace of mind, knowing that you've thought through all of the different pieces, that it's down on paper, that people who you love are protected. And that's really the piece that resonates with me. I think planning your estate is one of the most loving things that you can do for your friends and family. Because think about it this way. When you pass away, who's left to deal with not just all the practical pieces that need to be dealt with, but the emotional component too? We're talking about your friends and family. The people who love you the most are going to be grieving your loss. So to also heap on them the figuring out what you may or may not would have wanted, what you want to have happen with your property, it's almost cruel in some ways to add that to their plate. So planning ahead, I think, is one of those really loving things to do. For people who haven't done any sort of planning, it can feel daunting with respect to understand where to start. And so I think these 4 questions are a great starting point. What do you want to have happen to what you own when you die? Are there people you are legally responsible for, like minor children, for example? Are there people who maybe you're not legally responsible for, but you still want to take care of in some way? So grandchildren or adult children. And if you're in a situation where you're still alive and you're unable to make decisions, who do you want to make those decisions for you? Now, these are still very big picture questions, and you will still have to do some drilling down, but they're a good starting point. So let's think about what you own. There are, of course, physical, tangible things you might own, and those really go into 2 categories. So real property is things like a home or a piece of land. But then there's all the personal property that we often own. So that could be a car or family heirlooms or the Christmas ornament collection. It's the things that you value that you could, almost pick up and move to another location or drive to another location. And then there's the non-physical components, the things that you own. So accounts, life insurance policies, retirement accounts, bank accounts, stocks, bonds. Those are still your property. You just don't have a physical thing for it. Once you've inventoried everything that you own, both real property and personal property and non-physical, it's sometimes helpful to also figure out what it's worth. Now, this may or may not matter to you. Where I see this come up for some families is if they have, 3 children and they want to make sure that their estate is divided equally between the 3 children. And so understanding what each piece of their estate is worth can help them do that. So how do you figure out what it's worth? Well, certainly you can do an appraisal for things like real property. You can also do an appraisal for personal property to get a dollar amount of what it's worth. But I would also say when you're thinking particularly about personal property, don't underestimate the sentimental value of certain things. So an example in my family is we have a cedar chest that's been passed down for a couple of generations now. And if I were to go sell that cedar chest, it'd probably be $100 or $200, right? It's not a huge amount of money, but there is a huge sentimental value to my family. And so that cedar chest has to be included in, right now, my mother's estate plan. You also need to not just understand what you own and how much it's worth, but how you own the property. So some property ownership is decided when you buy it. There's sometimes property that when you purchase it or acquire it, you're going to write down who the beneficiary is. So a good example of this is a life insurance policy. When you purchase that life insurance policy, you say who's going to get the proceeds of that policy. You designate or name the beneficiary. So that ownership, it's your property, but the beneficiary has already been decided. For other types of property, you could own it individually or sole ownership. So maybe I go to the car dealership and I put down all the money to buy a car. I pay for the car outright. I'm the only person on the title. I own that car solely. There's lots of people, particularly couples, who own property jointly. And so it could be something like a bank account. If you own that as a tenancy in common, you each have rights to a portion of that. So let's say you and your best friend own a 4-unit apartment building. You put equal amounts of money into it. You then technically own 2 units and your best friend owns 2 units. You each would put ownership of your own 2 units in your wills. So you have a tenancy in common, you own it together, but you each can will your respective portions to whomever you'd like to. That's very different than joint ownership with right of survivorship. And this is how most married couples purchase homes in the United States. And the major difference in this is that, yes, you both contribute theoretically to purchasing the home and you're both on the title for that home. But when one person passes away, the entire ownership transfers to the other person automatically. So you wouldn't put like 50% stake in the house in a will without you both agreeing, okay, both of you pass away, then who gets the house? I know that's a lot, but it is important to understand how you own the property because that's going to dictate A, what documents you might need, and B, how you're going to deal with that property in the documents. So I'm going to talk about a number of estate planning tools. Not all of these tools are going to be relevant to your situation, but there are a few, and I will point them out when we get there, that I think everyone over the age of 18 should have. And the first is a will. A will is a legal document where you are going to deal with most of your property and where you're going to name guardians for minor children. The reason I say most of your property is because things like those life insurance policies or retirement accounts where you've already named the beneficiary, those don't get included in a will because you've already indicated who gets that money. There are lots of different types of wills. So there's holographic wills, which are handwritten wills. There's fill in the blank wills. There's kind of DIY used with a service kind of will. One great example of that is freewill.com, where it's a website where you answer some questions and then you tell them what state you're in. And at the end, it gives you a will to print out and then get witnessed. So it's a great tool for people who have a very simple estate. And then there are wills obviously created by estate planning attorneys. You do not need an attorney to create a will. And the number one reason I hear from people that they don't have a will is that they can't afford or find an attorney. I'm going to say it again. You absolutely do not need an attorney to create your will. That being said, for people who have complex estates or complex families, sometimes having a will drafted by an attorney could be useful. So if someone has property in different countries or different states, or, there's lots of stepchildren or contentious relationships, sometimes having a will created by a lawyer can help people avoid pitfalls. But for many, many people, one of these either statutory wills or using a service like LegalZoom or freewill.com is perfectly sufficient. Now, to create a legal will, there are some requirements you have to meet. In every state, you have to be over the age of 18 or an emancipated minor, and you have to be of sound mind, which is the legal term for you understand what it is that you're doing. This comes up sometimes in the context of an individual with elderly parents who maybe are dealing with dementia, and they'll reach out and they'll say, can we get my father a will now, or can we get my grandfather a will now? And unfortunately, if he isn't deemed to be of sound mind, and there's someone who could potentially contest that, it's going to be a problem. So creating your will and your estate plan is something you're going to want to do sooner rather than later. And then the rest of these requirements do vary from state to state, but generally wills have to be in writing. They have to be signed and dated by you, the testator, the person creating the will, and typically witnessed by 2 uninterested people. So the witness requirements are the things that vary the most from state to state, but we do have a chart on triagecancer.org that outlines the requirements for each state. So when you're creating a will, there are some pretty standard decisions you have to make. So the first is, well, who are the beneficiaries? Who's going to benefit from the will? And beneficiaries can be very general, or they can be really specific, or some combination thereof. So an example of a general beneficiary listing would be, leave everything to my only child. Or a specific could be, I want my daughter to get my engagement ring, and I want my son to get my vintage Corvette. Or it can be, again, some combination thereof. Beneficiaries don't just have to be people. So it can be an institution or an organization. You know, lots of nonprofits have situations where people will donate a portion of their estate when they pass away to a nonprofit that has helped them, or a university or a hospital. So first step is, who gets the stuff? Second step is, if you have a minor child or children or other dependents, you need to name guardians. And then the third step is, who's going to be the executor of the estate? Now, the executor is the person that is sort of in charge of dealing with your estate once you pass away. So some people will name a friend or a family member. Sometimes if you have an attorney create the will for a fee, they will be your executor. Some banks offer this service for a fee. Now, the reason I say that there's a fee involved with an executor is because there's actually a lot of steps. So someone has to find the will and file it with probate court. They have to then find all the assets and deal with distributing them. They're the person that's in charge of notifying all of the agencies and the people involved. They may even have to pay ongoing expenses. So like, while the estate is being dealt with, the gas still has to get paid at the house, and bills still have to be paid. And the executor may even also have to file a tax return on behalf of yourself. And so it can be a lot. So thinking about if you can write in a compensation piece to compensate the person who's being your executor is something some people like to do. Now, next to I can't afford or find a lawyer, the second most common reason I get for people saying why they haven't created a will is a fear of not being able to change the will over time. And I'm here to tell you, you can change your will as often as you'd like. The one caveat is that you have to do it in the right way. So you can't just cross people out and write people in, or write new things in the margins. You have to change your will through what's called a codicil, which is just a fancy word for an amendment. And the amendment has to be executed the same way you execute your will. So if in your state you need to have 2 witnesses watch you sign, then that's how you have to do the codicil as well. So you can absolutely change it, just make sure you do it in the right way. And then I often suggest to people, if there's a lot of changes that you're going to make, sometimes scrapping the old one completely and starting over is actually easiest. So what happens if you don't have a will? Well, you're going to have a more complicated probate process, which is going to also be more expensive. And that money comes out of the estate. So if you were hoping to leave money to your family members, that money is getting taken out to pay for the probate process. So they're going to get less. You also have no choice in the matter. So every state has what's called an intestate succession law, which basically means there's a particular order that the state has said the property gets distributed. So it's, again, different from state to state, but it might be that it gets split 50-50 between 2 children, or it gets split 50-50 between your parents and your sibling. Well, maybe you're estranged from your sibling and you don't want that person to get money out of your estate, or maybe they have a huge gambling problem and it wouldn't be good for them to get money in that way. So it really takes all control out of your hands to just let it go to probate and intestate succession. So I strongly urge you to think about creating a will. And here's just a quick checklist. This is available on triagecancer.org. We have a checklist called Getting Organized. You can download it for free, and it kind of outlines all these different to-dos when you're thinking about creating a will. So the next big document is a trust. And a trust is where, excuse me, you actually are transferring ownership of your property to this legal entity of a trust. And then the trust now owns that property. You might be thinking, why would I ever transfer ownership of my property away from myself? And there's a number of reasons. So it can provide control, it can provide protection, sometimes there's tax savings. It also helps save on probate savings. Now, a trust is a situation that is and. So you have a will and a trust. It is not a substitute for a will. And there's two main reasons for that. The first is that if you have to deal with guardianship can only be dealt with in a will, not in a trust. Also, there are a number of things that you might put in a will that don't have legal ownership in that way. Remember my cedar chest? That wouldn't get put into a trust because there's really no value to it. There's no title to it. That would be something more appropriately dealt with in a will. So you want the will and then potentially adding the trust. And there's a number of different types of trusts. These are just a few of them. The most common is what's referred to as a living trust, which is one where you create the living trust and then you are the trustee, the person that handles everything related to the property in the trust until you die. And so you can decide to sell things or add things or change the terms. So it is very, very flexible as long as you become the trustee. Again, some people are like, I don't get it. Why would I make a trust? It's not appropriate for everybody. There is an expense involved in creating a trust. And there's differing opinions. Some people will do a trust DIY using a service. I personally think that creating a trust, it's helpful to hire a lawyer to do that. The reason is that you're transferring ownership away from yourself. And so if you do something wrong or incorrect, it's very hard to come back from that in certain situations. But again, it's not a requirement to have a lawyer do your trust for you. Now, excuse me, I'd like you to meet Alice. Alice is a single mother of an 8-year-old son. She's an only child and her parents are no longer alive. Last month, she moved to Denver with her son and 2 dogs. She has cancer, and today she's headed to sign papers with her new employer to enroll her in benefits like health insurance. After dropping her son off at school, Alice realizes that she forgot her wallet and checkbook at home. Her landlord told her she would need to pay rent today or he would give up her apartment. She decides to head back to get her wallet before driving to the office. But before she makes it home, she's in a severe car accident. Alice is unconscious at the scene and is taken to the hospital in an ambulance. Alice doesn't have her wallet, so they don't know who she is or even if she has health insurance. She needs surgery and a blood transfusion. However, the healthcare providers don't know if she has any preferences for medical care. And oh yeah, Alice's son needs to be picked up from school, the dogs need to be fed and let out, the rent needs to be paid, and she's going to lose her apartment, and paperwork needs to be signed for her health insurance to be effective. So Alice really sets up the situation where somebody needs to think about having the proper documents in place when they're still alive, but they're unable to express their own wishes. And the first document is the power of attorney for financial affairs. This is where you name a person, your agent, to conduct financial affairs on your behalf. There are 2 types of powers of attorney for financial affairs. The first is a standing, which takes effect as soon as you sign the document and continues if you were to become incapacitated. Now you might think, well, why would I want it to take effect right away? There are many reasons. So it could be that maybe you have your best friend helping you talk with the insurance company on your behalf. It would be helpful for them to have a power of attorney for financial affairs to conduct business on your behalf. Sometimes people who are in the midst of cancer treatment don't have the capacity to deal with their bills and the mortgage company and the bank and file taxes. And so naming a power of attorney for financial affairs to do those things on your behalf could be helpful. Many people, absent sort of a extenuating circumstance, create a springing power of attorney for financial affairs. And that's where you could sign it today and it would never go into effect unless you were in a situation where you were incapacitated. In most states, it has to be signed by you and notarized. The added protection here is that they want to make sure you're giving someone power over your finances. You want to make sure that that's really what you want to do. And powers of attorney for financial affairs end the moment you pass away. So they cannot be used as a substitute for a will or a trust. So here again, we have another and. A will and a power of attorney for financial affairs would be useful. So this is just about what are the kinds of things that a power of attorney for financial affairs could do. They could pay your everyday bills. They could make deposits or withdrawals at the bank, handle your taxes, invest money in stocks and bonds. So you can also limit the power of attorney, but this is sort of general things that they are typically allowed to do. Now, that's finances. What about medical care? So when you think about planning ahead for your medical care, there's kind of two pieces to this. The first, and these bullets should probably be reversed, but the first is about what do you generally want for your medical care if you're in a situation where you're unable to express that, whether it's for a short period of time or not. And then what do you want at the end of life if you're unable to express those wishes? There are different documents that can be useful in these situations, and we're going to go through each of them. So the first document is a living will. Not to be confused with the wills we've just talked about. I don't particularly like the term living will because I think it's confusing for a lot of people. I like to call it instructions for healthcare. This is where you have a document where you can outline if there are particular treatments you do or don't want. So some people have religious beliefs that don't allow them to receive blood transfusions. That would be something to include in a living will request. I feel very strongly that there is science that I don't need to be in pain unnecessarily. So please give me all the pain medication available. So you can say, yes, please give it to me, or no, don't give it to me. You can also dictate location of treatment in an instruction for healthcare. So there are some people who feel very strongly that they want to be at home for their end of life. Conversely, there are some people who absolutely don't want to be at home. I'll never forget a young mother that I spoke with who didn't want her children's last memories of her in their home to be of her dying. So at a certain point, she wanted to be transferred to hospice, and she was able to put that in her living will. You can also include some information about organ donation wishes, autopsy wishes, and burial wishes in your instructions for healthcare. So that's one part. You can just create these instructions for healthcare and leave it at that. However, most of us can't think of every possible scenario or permutation that could possibly come up medically. And so to doubly protect ourselves, we could also name a power of attorney for healthcare. This is someone who can make medical decisions for you if you can't. And they're named all sorts of different things depending on where you are and what hospital you're in, but it could be an agent or a proxy or a surrogate. So it's very similar to what we were talking about with respect to the power of attorney for financial affairs, but this person can just deal with healthcare. You may in fact name the same person to be both your power of attorney for financial affairs and your power of attorney for healthcare, but you may not want to do that. For example, my husband is very, very good with money, so I would have no qualms naming him as my power of attorney for financial affairs. When it comes to medical things, he calls every pill that comes out of a bottle aspirin, whether it is a vitamin or an ibuprofen. So I don't want him anywhere near my healthcare. So I would name somebody else for my power of attorney for healthcare. With both power of attorneys for finances and healthcare, you can name multiple people. But if you do, and it's a good idea because you never know if someone's going to be available or not, always name alternate agents and name them in order. Never name co-agents. And the reason for that is that co-agents could potentially disagree. And then what happens? So alternate agents is great, co-agents is bad. So who can be an agent? Well, really, it can be almost anybody. Generally, they're going to have to be over 18. It shouldn't be your healthcare provider or someone employed by your healthcare provider, or if someone's in like a residential or nursing facility, it shouldn't be an employee of that facility either. So it's pretty broad here. Some of the things that an agent might be able to do is hire or fire providers, decide on tests or medication. They can make decisions around artificial hydration and nutrition, moving to different facilities, and sometimes even apply for benefits related to healthcare, like Medicare or Medicaid, if necessary. There are some limitations for an agent. Some are written into the law. So for example, an agent couldn't authorize an abortion. But outside of these pretty extreme things limited by law, you can also write in your limitations. So you can flat out say, like, do not keep me alive if I'm going to remain in a coma. Or you can make every decision for me except blood transfusion. I don't want blood transfusions. So there are some limiting pieces in here. Now, when we talk about advanced healthcare directives, it could just be a living will. It could just be the power of attorney for healthcare, or to be most protected, it could be both together. And I really recommend that everyone over the age of 18 have 4 documents: a will, a power of attorney for financial affairs, a living will, and a power of attorney for healthcare. I think if you have those 4 documents, you can do a lot to protect yourselves and your loved ones. Now, some states have fill-in-the-blank advanced healthcare directives, and those fill-in-the-blank ones may have additional pieces to them. So they could include resuscitation instructions, they could include organ donation information, and then all advanced healthcare directives have to be signed and witnessed. The witnesses, there's some more limitations here. So you have to have one witness that isn't your agent, isn't related to you, isn't entitled to any part of your estate, isn't your doctor. They want to make sure there's at least someone involved in this that has no vested interest in your healthcare. People get tripped up by this, like, well, wait a minute, you just named everybody I know. Think outside the box. So can you ask your next door neighbor that you're just casually friendly with? Can you ask, your pastor or your pastor's spouse to sign this on your behalf? Do you have a coworker you might be able to ask? Because all they're doing is witnessing that, yes, this is your advanced healthcare directive, and yes, you are willingly signing this document. Some states also allow you to bypass witnesses altogether and just go pay and get a notary to notarize it. A question I get a lot, excuse me, is about organ donation in the cancer community. So there are actually 2 different main types of organ donation. One is about live donations. And so that's where, your organs would be given to a live recipient, which once you've received cancer treatment is really not possible as far as I've ever learned. But there are still options for whole body donation. And that's where information or your body or your organs can actually go to be used in research. And so there's sciencecare.com has a phenomenal website where you can actually see the difference and what that means and how you can put limitations in. And you can actually register that as well. So if you are interested in organ donation, but feel like you're barred from doing so because of your cancer treatment, this might be a good option. Now, a couple of other documents that come up a lot are Do Not Resuscitate Orders, or DNRs. These are really limited documents. So they are just telling, typically, emergency first responders not to perform CPR. That is the only thing this document is telling people. It's very, very limited. Another document that comes up is the POLST, or the Physician's Order for Life-Sustaining Treatment. These are documents that are really only for seriously ill patients or those who are considered medically frail, regardless of their age. And it's typically at end of life, and it's where you can outline the medical treatment you do or don't want to receive towards the end of life. And so there are kind of different options that someone can pick. It's usually on one of these very bright colored pieces of paper. And if someone has a POLST form filled out, they do so with their healthcare provider, and the healthcare provider signs off on it. And then it's usually either kept with the person on, like, in their wallet, or if they're in bed, then it would be like on their nightstand or on a refrigerator. And it tells first responders, like, do you want to go to the hospital? Do you want to be put in the ICU? Do you want to be put on a breathing machine? Maybe you want to go to the hospital, but you know what? No ICU or breathing machine. Some people say no hospital, just allow for natural death. So again, this is something that you would have and in addition to an advanced healthcare directive, and it's for a pretty specific period of time in somebody's life. It's a lot, everything I've just talked about, and I know there's a lot of different forms, and you might be thinking, like, well, wait a minute, what do I need? What don't I need? This is sort of a breakdown. So a living will, it's a legal document. All adults should have one of these, whether you're healthy or not. And it's where you are providing your instructions for healthcare. You're going to sign it, and some people that you know are going to sign it. The power of healthcare, power of attorney for healthcare, is also a legal document for anyone who is healthy or sick. You're naming an agent. Again, you're going to sign it yourself, and you're going to have it witnessed. A DNR is a medical document. Any adult can have one, but typically people don't create DNRs unless they have an illness that they are dealing with. And they're telling someone, do not perform CPR. A DNR is something you would really the conversation would be between you and your patient, or excuse me, between you and your doctor. And then a POLST is, again, a medical document that you would only have if you had an advanced illness. And again, you're going to have that conversation between you and your doctor. So it may be that someone actually chooses to have all four of these documents at some point. But at the very least, the first two, I think, are important for everybody to have. So what happens if you don't plan ahead? Well, you could end up with a conservatorship. And so this is where a court comes in and appoints a person to act as your agent. There are two types. So conservatorship of the person, so that's going to be about healthcare, and then conservator of the estate, which is about the finances. There are times when courts, like, there's a group of people sitting in the waiting room who have said, like, yeah, I'll be a conservator. And then the court says, okay, you're this person's conservator. So you could have a perfect stranger making these decisions for you if you don't have these documents in place. I also want to address a couple of non-legal wills because they come up in these conversations. So sometimes these are called ethical wills or legacy letters. 5 wishes is an example of these, where they are not legal in every state, but they do have a really great purpose. So they're a way to express your wishes that maybe it don't need to be in a legal document, a way to pass down knowledge and beliefs and stories and traditions. Wonderful, really, really great things to do for your loved ones, not the same thing as a legal will. So again, it would be another and, not an or. Now, here are some other things just to think about, and then I'll make sure I leave time for questions. But you want to make sure you've thought through who has access and who needs access to what. So if you live alone and you're the only person with the key to your home, that could potentially be a problem. If you create all of these documents and then store them in a safety deposit box at a bank that only you know exists, and you're the only signatory with the only person with the keys, that's not useful. Same thing though for storage units and bank accounts. Make sure that at the very least, someone other than your spouse or your partner knows that these things exist and where they are. I say that because partners, spouses, spend a lot of time together. If you are traveling and there is an accident, you are probably going to be together. And so just relying on the idea that, oh, my spouse or my partner knows where this information is or knows where the keys are or has the code, that may actually not be enough. And so thinking about at least one other person in your life that at least has a way to access this information is important. Another thing that a lot of people don't think about is their digital property. More and more of our lives are being lived online in a number of ways. And so it is helpful when you're thinking about your estate plan to also think about these digital components. So access to email. I know I would be delighted to never have to deal with my inbox again after I pass away, but here's the thing. Almost all of my bills get sent to me electronically via email. So someone else needs to be able to access that in order to continue paying my bills if I'm incapacitated or if I pass away. The same is true for your cloud storage or social media accounts. I mean, I know my children's entire existence up until this point is documented in pictures and videos that live on the cloud. So if my spouse or my executor doesn't have access to that cloud account, all of that gets lost. So different platforms have different ways to deal with this. For example, Facebook allows you to actually go into your settings today and name a legacy contact that has the authority to turn your page into a memorial page or contact Facebook to have them shut it down. Gmail has a place where you can name an account manager who can come in and again, access your email legally and deal with your digital afterlife. That's Gmail's language. So think about what platforms you're on and what storage systems you use and how you might give somebody access to that. Now, it's a lot, I know. So how can we organize this information? This is our financial big picture document that we've created at Triage Cancer. It's downloadable from our website, either as a Google Sheet or an Excel document, and you can delete the information that's in there and fill it in with your own information. And not only is it helpful as like a financial tool, but it also has a place where you can put the account numbers and the logins and any notes for accounts that you might have. Certainly you'd want to save this in a very safe place. Maybe you don't want to save this online, but you'd rather have a paper copy saved somewhere. And then let your executor know that it exists, because that's going to be key to them being able to help access all of these accounts and distribute your property. We've talked a little bit about storing documents already. There's a couple different strategies. So when we're talking particularly about advanced directives and powers of attorney for financial affairs, make sure that all the people that need access to those documents have access. If we're talking about things like DNRs or posts, again, I mentioned you can post it by your bed. I think it's tricky to deal in hard copies because you could be traveling and get a call from, your power of attorney for somebody else, and you're traveling and you get a call and you're like, oh, I don't have the document on me, I'm traveling. So one strategy is to use online storage systems. None of these documents have information in them. It's like you don't have passwords or account numbers in these documents, right? It's especially your powers of attorney. And so you don't need to be terribly concerned about putting something like that online. A couple different strategies. If you are concerned, there are paid services that are encrypted to a very high level where you can upload these documents and then give people access to them. Personally, I use Google Drive. So I have a folder in my Google Drive. I have my documents saved in there. And then my executors, the guardians, and the power of attorneys all have that Google link. What's helpful about that type of strategy is when I make changes to my documents, I just take the old ones off that drive and put the new ones in. So A, wherever they are in the world, as long as they have Wi-Fi, they can access the documents. And B, they always know they have the most up-to-date documents. Of course, Google Drive isn't the only one. iCloud has a similar service, Dropbox. Again, there are some paid services you can use as well. And then when we're talking about making sure that as many people as possible that need the information have the information, sometimes it's helpful to use what is often in the palm of our hands. So most smartphones now have a way where you can upload medical information into a emergency contact. So I've shown you Apple and Android's way to do it here. And what's great about this is that first responders are actually trained to access this information without your passcode. So you can list any medications you're taking, you can list your emergency contact. There's a notes section. So I have in mind, like I have an advanced directive, call this person, so that they can access that if I'm incapacitated. So remember Alice, that would be a good solution. There's also low-tech ways to do this. So there's jewelry, there's traditional bracelets that are available. I've just recently seen this really cool one that's like on an Apple Watch band. So if you are concerned about, if you're often by yourself and you want to make sure that information is available to who needs it, these might be good tools. And then finally, funeral planning. So funeral planning can be very daunting and very expensive. And if it is something that you have the capacity to think about and deal with, you may want to do this sooner rather than later. So there are ways that you can actually pre-plan your funeral with funeral homes or crematoriums. You can sometimes create payment plans so that either that money is not coming out of your estate or it's not on the shoulders of your loved ones. I also, again, it comes back to that loving thing to do. I'll never forget, I was speaking with a gentleman who lost his wife, and he was in a very challenging financial situation. And he made a comment about how he maybe shouldn't have spent so much on her funeral, and we talked a little bit more and found out that he spent quite a bit of money on her casket. And when I asked him why, he said he just didn't have the heart to give her the sale casket. And then he laughed through the tears and said, but she would kill me, like she was the couponer, right? She would kill me if she knew how much I spent on that casket, but I emotionally couldn't do it to her. And I just thought it was such a stark example of, if they had been able to have a conversation and plan this before she passed away, he might have been in a very different situation at the end of all of that. And it's, again, a very stark and unique situation, but I think it kind of illustrates why this can be very helpful. So to sum it all up, no two estate plans are going to be exactly the same. It has to be one that works for yourself, but think about the different documents we've talked about and what makes the most sense for you to have. It is also not a one-time chore, unfortunately. I do think you should review your estate plan periodically. When, like how often? Well, that's really going to depend on you and how often your life changes. If you're someone who babies are being born into your family, every other week, maybe you're going to want to review it every year. If you're someone who buys and sells a lot of property, you're going to want to review it every year. If you're someone who, everybody's been born and you live in one house, then maybe, once every 5 years is sufficient for you. So you're going to want to make sure changes in your family, you're looking at that. I think also changes in your friend space too. So you may have named an agent that maybe right now you don't think would be the best person to be your agent. And changes in your wishes too. I find that as people, particularly through the continuum of cancer care, their wishes may change about medical decisions or even financial decisions. I know I sound like a robot, but please make sure many people know where all the pieces of your plan are located, and that everyone who's involved, the agents, the providers, the executor, know where your documents are, and you've talked about your wishes with them. I do just want to mention before I'm going to take questions that Triage Cancer has an estate planning toolkit available on our website. It's 3 parts. The first part is a pamphlet that talks about the general information, much of what I've discussed today. Part 2 is any information specific to your state. So we have all 50 states. And then part 3 is if there are statutory fill-in-the-blank forms available for your state, we've compiled them all into one PDF. So you can go and hit print once and have all the documents that you would need to complete right there. And that's all available for free at triagecancer.org under estate planning. I will also just say that there are so many other things that we talk about at Triage Cancer. And so in addition to ThyCa being an incredible resource for you, please know that Triage Cancer is here for you as well. We have a number of ways to learn about this information, including live and online events, one of which is coming up. It's our biggest of the year, and we will be hosting it in person in Chicago if you are local. We will also have it hybrid online, and that's going to be on October 1st. And all you have to do is go to triagecancer.org and register. I will also say that one of our newest resources is our legal and financial navigation program. And this is where you can fill out a form on our website and schedule a call with one of our expert staff to talk about whatever questions you might have or the situation that you're in. The most common topics we talk to people about are around health insurance, employment, disability, and estate planning. And so if something comes up after today's session, you're like, oh shoot, I should have asked that. The navigation program is the way to get answers to those questions. And all you have to do is go to triagecancer.org/get-help. So with that, I'm going to ask Timothy if there are questions.
Yes, Monica, we have one question. It is asking actually for a cost summary, if you can give somewhat of an estimate for that, for what a will, trust, power of attorney, and living will might cost.
I wish I could, but it really is going to depend. So, trusts could, depending on the complexity of a trust, that could run you $10,000. I've also seen trusts be created for about $1,000. Typically, if you're going to go to an attorney and pay for a trust to be created, most good estate planning attorneys will also include those other documents as well. So a will and a power of attorney for financial affairs and an advanced directive. But I will say to you, other than the trust, before you go hire a lawyer, check out that estate planning toolkit for your state and see if there are forms that you can use, because it may be that it doesn't need to cost very much at all. And unfortunately, there's really no other way to ballpark it because it's going to depend on where you live and how complex your situation is. But know that you can also shop around for lawyers. So you can ask them, what do you typically charge for creation of these 4 documents? Is it a flat fee? Is it an hourly rate? Because that's obviously going to depend. How many revisions do you allow? So if they say like, we're going to charge you a flat fee for these documents, how many revisions do you allow in that flat fee? Because you want to make sure that you can get it right. So I'm sorry that wasn't a concrete answer, but it's the best I can do.
Thank you, Monica. If there are any more questions, feel free to submit them in the Q&A. And while we wait, Monica, if you have any final comments you'd like to make?
I would just say that I hope you all are having an incredible conference so far, and that you found today's session useful, and certainly that you'll continue to have a relationship with Triage Cancer as well as ThyCa.
Thank you, Monica. We do have a couple things that came in here. This first one looks like a statement more than anything else. A payable on death form at the bank is also very important, this person is saying. They are recommending that it keeps funds from going to probate. If you have any comments on that.
Yeah, It can be useful, but it's not 100% avoidance of probate, particularly if there are creditors to the estate. And so it's not a complete, it's a good idea. There's nothing wrong with them, but just know that you're not completely locked in and protected if there are creditors to the estate, particularly if that bank holds a mortgage, for example.
Okay. And our next comment here is simply thanking you for the great explanations today. She said it's a great topic.
You're very welcome.
And another thank you. All right, with that, I think we will wrap up this session. Thank you very much once again, Monica, for coming today and talking about this very important topic with all of us. It's greatly appreciated by not only myself, but everyone that has come here. And I want to remind all the attendees today that the speakers that come to this conference are not compensated. They come here of their own free will, and they donate their time and their expertise. And so, again, we definitely thank Monica's expertise and time today, because we know it is from the bottom of her heart, of course, and she does this work very graciously. So thank you very much again, Monica. Have a wonderful day, everyone.
You're so kind. Well, thanks all for coming, and I hope you have a great rest of your conference.